Thank you. Boozhoo. Come on, let's try that again. Boozhoo. Awanakwe Nadishika. My Indian name is Awanakwe, which means mist woman, and that is because the person who gave me my name said that when she was dreaming and praying about what my Indian name should be, it came to her that it would be Mist Woman, which is the mist that overlays the White Earth Nation in the morning, as I am a protector. So that's kind of cool, and I thought I'd wake you up by having said that. I've noticed that none of you, or at least very few of you, are wearing cowboy boots. I would remind you, we are in Nashville, as in Nashville, Tennessee, so I have my red cowboy boots on for you all. And we are the last panel, but we are going to make sure that we keep you all awake. They're gonna knock it out of the park, right? Right, yeah. If we need to resort to physical violence, we shall do that. So let us start. I'm going to just introduce our distinguished panel. To my immediate left here is Matthew Pawa. Matthew has been involved in many of the nation's most important environmental cases over 25 years. He is a partner and chair of the environmental practice at Seeger, Weiss, L.L.P. I find it interesting that he is also the host of the Mother Earth podcast. So I'm going to listen to that. And more importantly, he is a Jayhawks fan, as in the Jayhawks, for his favorite musical artist. Anybody know who the Jayhawks are? Okay. Minnesota, played at First Avenue, and he flew there. So you get brownie points for that. All right, so next we have Mr. Phil Goldberg. Phil Goldberg is the managing partner and co-chair of Public Policy Practice Group. He has also got 25 plus years of experience, and it says here that he is a voice for common sense, so we shall see. Now, he tells me that Bruce Springsteen is his favorite musical choice, so, you know, I think that's not bad, right? Anybody like Bruce Springsteen? Come on, people, wake up. All right, then we're going to number 3, Mr. Mark DeLaquil. Mark is an experienced advocate who focuses on appellate practice for complex environmental and regulatory proceedings and political law. He has also been named in Law 360 as one of the top 5 environmental attorneys under the age of 40. I could say something, but I shall not. But Mark is a Johnny Cash fan, the man in black himself. So just for that alone, he gets brownie points. All right, come on. Johnny Cash fans? All right. Then we have J.B. Ruhl. Mr. J.B. Ruhl is Distinguished Chair in Law, Director of the Program on Law and Innovation, and Co-Director for Energy, Environmental, and Land Use Program at Vanderbilt University Law School. And more importantly, he is a Led Zeppelin fan.
Yeah.
Okay, there we go. Now we know what kind of an audience we got. And last but certainly not least, batting cleanup is Mr. Jonathan Adler, who is a professor of law and director of the Coleman Burke Center for Environmental Law. He has written many books and articles. He's testified before Congress, and he is a Miles Davis fan. And with that, we're going to kick it off with Matthew.
Thank you. Matt Pawa, good to be with you. Thank you. It's an honor and a privilege to be part of this distinguished gathering of highly accomplished lawyers and professors and judges. So I appreciate being included. Climate change. When climate change injures, who should pay? That's the central issue that we're concerned with on this panel. Start with basics. We know that climate change is causing serious injuries. In 2018, for example, the Camp Fire, deadliest fire in California history, destroyed Paradise, California. Here's another example. In 2020, the town of Phoenix, Oregon, basically destroyed, largely destroyed by a climate change fueled wildfire. Hurricane Sandy, we're all familiar with that in New York City. So we know that harm is occurring from climate change. It's graphic, it's real, and it's killing people. It's killing property, it's destroying property. I agree with Victor Schwartz. The nuisance action originated in the 12th century, which makes it distinctly not novel. And if I could respectfully disagree with the premise of some of what brings us here today, I want to try to convince you that not only is nuisance not novel, but the application of climate change is not novel. It deals with public rights, as we've heard from others, and with private property. Private nuisance dealing with private property and land, and the invasion of the plaintiff's interest in the use of his land or her land. And the interference with public rights is public nuisance. Okay, 5 points. Point 1, the problem of multiple polluters contributing to a nuisance is a familiar and old problem in the law. One of the first things people ask me about when I talk about litigating climate change is, how can you select who to sue? There's so many contributors. So first, let's back up the clock to the 19th century. 3 informative cases, all cases where downstream landowners or an attorney general sued 1 or 2 of a very large number of polluters who were fouling a river. And in the 19th century, the court said, well, it's true that your pollution standing alone wouldn't cause the nuisance, but you contribute to the nuisance. Even if you wouldn't cause it with your pollution standing alone, you are nonetheless liable. Bring that forward to the 20th century, it is now a damages doctrine as well as an injunctive relief doctrine. And as Judge Posner said, even if the amount of pollution, he's quoting from Prosser Keaton, caused by each party would be too slight to warrant a finding that any one of them had created nuisance, pollution of a stream to even a slight extent becomes unreasonable and therefore a nuisance when similar pollution by others makes the condition of the stream approach the danger point. So this is Judge Posner speaking, not me. From the restatement second of torts, it is immaterial that the act of one of the defendants by itself would not constitute a tort if the actor knows or should know of the contributing acts of others. And this is from the nuisance section of the restatement. So this is a familiar problem. How does it play out in climate change? Well, we know from the peer-reviewed published literature, in the carbon majors studies, that there are a limited number of very large companies that have emitted a large percentage of the greenhouse gases. Going back to 1820, you can attribute 70% of the methane and carbon dioxide from fossil fuel combustion and cement production to just 108 companies. And if you wanted to look at more recent times, 1965 to 2018, this study also shows that the top 20 producers of fossil fuels are responsible for 35% of the global total. So in fact, there's a relatively manageable number of companies that one could sue as defendants that are largely responsible or significantly responsible for the problem. And it plays out against the backdrop of law going back 100 years, finding that you don't need to be the only one causing the nuisance. In fact, there can be many, many, many polluters of a river, or in this case, the atmosphere, and you can be held liable. In fact, the burden is on the defendant to show that the harm can be divisible and allocated to others if they want to defend on that basis. All right, point 2, manufacturer liability. You've already heard a lot about this today. Section 834 of the restatement, second of torts, just says straight out that anyone who participates to a substantial extent in carrying on an activity causes a nuisance. One of the examples given in the restatement is smallpox as a nuisance, which is certainly not tied to the defendant's use of land. All of these pollutants or substances manufactured by various companies have been held either on a motion to dismiss or at a full-blown trial and judgment on the merits, upheld on appeal, to be a nuisance when manufactured. Asbestos, MTB, a gasoline additive, PCBs, PFAS, the so-called forever chemicals, which are a very hot topic in litigation now, which I'm involved in, pesticides, opioids, lead paint. Now, you may think that manufacturers should never be held liable in nuisance, but I would just respectfully submit that if all of these manufacturers can be held liable in nuisance, that there's no reason that a fossil fuel producer should get a free pass and have any different rules apply to them than other manufacturers. Now, the defendants have come up in the climate change cases with a very clever theory to say, no, we should have a special rule. And this is a novel and interesting argument. They said there's a balancing test in public nuisance, and when you do the balancing test, of the harm versus the utility of the product, you're bringing in such a large issue. The entire Industrial Revolution versus all of the harm of climate change, that balancing test intrudes onto the legislative and executive branches. Problem with it is there is no balancing test. And I'm not making this up, straight out of the restatement. An intentional invasion of another's interest in the use and enjoyment of land is unreasonable if the harm resulting from the invasion is severe and greater than the other should be required to bear without compensation. No requirement of any balancing test. So the whole basis for the separation of powers argument drops away when you dispense with the defendant's arguments about balancing tests. Point 4, unreasonableness is an allocation decision. Right? Public nuisance is an unreasonable interference with rights common to the general public. And I'm not going to read this whole quote to you. You can read it for yourself. But Prosser, Keaton on torts talks about this unreasonableness factor as, is the harm unreasonable? And if it's unreasonable for the plaintiff to suffer the harm without compensation, there's liability. So the damages question, which is what all the latest wave of climate cases are all about, allocation, who should pay. The focus is on the harm to the plaintiff and whether or not the plaintiff should be allocated the burden of paying for that harm. The taxpayers, cities and counties and states are the plaintiffs of these cases, or whether or not the defendant should pay. And I'm out of time, so I'm just going to skip right to my final point here very quickly. The intent standard is fairly low. The intent is just that the defendant has created or continued the condition causing the interference with full knowledge that harm to the plaintiff's interests are occurring or are substantially certain to follow. And the evidence that's been attached to the complaints and cited in the complaints in the latest wave of climate change cases lays out a whole series of meetings by the fossil fuel industries and internal documents that journalists have unearthed. I'd show them to you, but I'm out of time. Demonstrating that fossil fuel companies knew as early as 1980, maybe even as early as 1968, that climate change would occur from the use of their products, and it would be very injurious indeed to cities, counties, states, and the public at large.
All right, thank you. Mr. Goldberg.
Thank you, Justice McKeig. Appreciate the introduction and trying to keep this fun and light for everybody. And Matt didn't get all agitated. I don't have chairs I can throw over his head yet, so stay tuned. That comes in the Q&A part, I suppose. And I want to thank Donald and the whole Law and Economic Center staff. They've done a fantastic job putting this together. It's nice not being a box on a screen. It's nice not having you all being boxes on screens. It's nice wearing pants and not shorts to one of these presentations, so all that is good. I also, in addition to being a partner at Shook, Hardy & Bacon, I am a special counsel to the National Association of Manufacturers Accountability Project. And the reason that manufacturers care a lot about this litigation is because these theories skip over core elements of liability, namely wrongful causation of harm. And to make manufacturers liable for a wide variety of social, economic, or environmental issues. So when we get to climate change, and I want to start where Matt and I agree with each other, and that is climate change is a problem. And the images that Matt showed clearly demonstrate that. And it really needs to be addressed at a global and at a local level. Electrification is widely viewed as the single greatest achievement for human health and standard of living increases of the 20th century, from refrigeration, heating and cooling homes, transportation, healthcare, factories, you name it. And how we reach those achievements in the 20th century is not going to be how we're going to get there in the future. And so what we need is to figure out, or the challenge of our time is how to live this modern life we've constructed without impacting the climate. And so what we need is innovation at a massive scale as to how we source and we use energy and do it in a way that's sustainable. Where Matt and I differ, and where the chairs may come out, is about the propriety of this litigation, the value of this litigation to solve that problem. Point blank, and I'm going to go through these 3 points in more detail, this litigation is not going to solve climate change. This litigation doesn't have legal foundation, and it's an unproductive distraction from actually achieving the goals that we need to get to. So I'm going to spend the next few minutes kind of breaking this down, and I'm going to start with history, because context is everything. So this litigation has been going on for about 20 years. And it started out with a very openly acknowledgement that they were trying to use litigation as a tool to regulate national emission standards and climate policy. And Matt and I were at a conference. It's funny, how more things change and more these stay the same. 12 years ago or so, where the title of the conference is at Valparaiso Law School, Litigation's Role in the Path of U.S. Federal Climate Change Regulation. And they said at the conference that this was born out of frustration that not enough was getting done in Washington on climate, and so they needed to take action, and going to the courts was one way to do it. And so the initial climate cases looked like an experiment in a laboratory of climate law, or tort law. So you had different types of plaintiffs, government plaintiffs and private plaintiffs. You had different defendants. You had users of energy, like utility companies. You had producers of energy, like oil and gas companies. You had different types of legal claims, federal claims, state claims. And you had different types of remedies that were sought, injunctive relief or abatement, damages type things. And the one case that got up to the US Supreme Court, A.P. versus Connecticut, was state plaintiff suing users of energy, so the 6 utility companies, under federal common law, public nuisance, seeking injunctive relief. And Justice Ruth Bader Ginsburg in a unanimous court said that's not the proper role of the courts. The legal ruling was that the Clean Air Act displaced the federal public nuisance claim. But the opinion went far beyond that and explained that climate change is a question of national and international public policy where balancing of interests need to occur from affordability, energy independence, other environmental issues along with climate change. And that this cannot be done on an ad hoc case-by-case basis. And at the time, there was a case sitting in the Ninth Circuit of a village of Kivalina, which is very much like the cases we're seeing today, where you had a local community suing the oil and gas companies for local harm, seeking abatement and damages type claims. And the Ninth Circuit dismissed that, saying what the Supreme Court just told us, it would be incongruous for us to revive this type of case in this other form. And so then Matt, I presume, and his colleagues went back to the tort laboratory in La Jolla, California, and said, okay, let's figure out, we still believe that this is our best current hope, I think was the quote, for imposing our national policy agenda on climate, to use the courts. And you don't have to believe me, they published a report, it's online, so everything I say right now is coming out of their report. And they emphasized making these suits look like traditional damages claims. And so they said, let's not directly ask the court to regulate emissions or tax carbon use. As one participant said, even if your ultimate goal might be to shut down a company, you still might be wise to start out by asking for compensation for injured party. And so this whole round of litigation is insisting that this is not about regulating emissions or trying to affect policy, where we're just asking for damages, it's about money. And then they added also the public relations component, because they said, in order to be successful, both to drive the litigation outcome and then to leverage the litigation to drive the public policy outcome, we need to figure out how to vilify the industry and try to create outrage in people's minds. And so then in 2017, the second round of litigation was born. And it was all based on sort of this playbook. And so they were packaged to look very different from AEP versus Connecticut, but they're trying to do the exact same thing as an AEP. And so instead of suing state, was suing energy users under federal public nuisance for injunction, it was municipalities suing energy producers under state public nuisance law for abatement and damages. And then you had the narrative on top of that about blaming energy companies and trying to delegitimize them as political actors, which one court has called lawfare. And so today you have two main legal theories behind this litigation. You have public nuisance, which is what we're here talking about today, and also Consumer Protection Acts, which is more recent cases have been featuring those. And why these legal theories? And you've heard all of this today. These are incredibly vague terminology, intentionally vague terms, because they're meant to apply to a wide variety of things, but within a specific bucket, with specific boundaries. And these cases are over here outside of those boundaries, and they want to take these vague terms and say, let's apply them here. And that's what this whole litigation is about, and a lot of what you've heard today, which is why it is novel in terms of the concepts of taking this 700-800-year-old tort and applying it to something to which it was never intended to apply. And so like public nuisance was about local disturbances and not about things like climate change. And the key missing elements, as I said at the beginning, are wrongful causation. So there's no wrongful conduct that are tied to the legal theories that they're saying need to be proved in court. So like unlike the last panel that said this was the bad acts law, it doesn't even need bad acts in order to find liability. And if you look at the New York City complaint that Matt provided in the materials, it's intellectually honest and very straightforward. It says fuel should incorporate the cost of the impact they cause. That's the liability theory. And the council in Boulder said the same thing. They said, our way of holding the consumers accountable for energy is to sue the manufacturers and hold them accountable. And this is about raising the costs of energy on people. You have others that are trying to leverage the so-called campaign of deception, but that's not borne any fruit in court. A New York court already has called it hyperbolic. In California, the plaintiffs acknowledged it was just a plus factor not required for liability. So that's just a sideshow. And then the causation, which you heard Matt say, let's get rid of legal and factual causation, and let's just replace it with some vague concepts of risk contribution to the larger issue. And then the Consumer Protection Act, which is really more of a rhetoric, it matches at least the rhetoric of this campaign of deception that the others are spinning. But that's not what the Consumer Protection Acts were meant to do. What they're meant to do is make sure that when you buy a gallon of gas, you get a gallon of gas. It's not about what externalities might occur from use of a product, or every product out there has externalities that you'd have to be telling people about. I mean, if I got wind energy, I had to be told about bird strikes, and hydroelectric would be about flooding issues and whatever products or externalities. It's not about political speech. It's not about what donors the owners of the company donate to. What political parties or what political interests they may give to. These are things that very well may affect somebody's purchasing decision, but that's not what Consumer Protection Act claims were intended to cover. And so you end up with what Professor Sharkey kind of outlined and acknowledged this morning, which is a defenseless lawsuit. So they sold a lawful beneficial product that we want, that has an externality we've all known about, and given that externality is arising, they should be liable for it, even if they're in a fully regulated industry with that's needed. And for me, a sure sign that a legal theory is not viable is that there's no way to avoid the liability. And finally, I just want to make a quick point about the practical cost of this litigation. I see that there are pieces of paper being held up, but I can't see the numbers because I don't have my glasses on, or else
zero.
I won't be able to. Okay. So I just want to. I want to finish with this one thing. And that is that there's a practical cost to this litigation. It's creating a carbon penalty without the public's ability to have input, no legislative ability on how much it should be, who should pay it, where, and how it should be spent. It actually can make climate change worse. And just as an example of that, I just point to a New York Times article from last week that talked about how there's a shift in production to OPEC countries, state-run oil companies, because a lot of the companies that Matt's talking about are pulling back their investment, and they quoted the chief executive of that company saying, of course, we're trying to benefit from the lack of investments by major players in the market. And they're not responsive to American policy making. They're not focused on climate and environment. And then third goes back to the concerns of the manufacturing community of just the fact that there are issues that are hard to solve. That doesn't mean we turn to the manufacturing community and say, well, your product is somehow associated with it, so therefore you have to be liable for it, and you have to pay for it. And so that's why the NAM cares about it. That's why I've been involved, and I appreciate the time. And if I've got negative minutes, Mark, it comes out of your time.
You definitely have negative minutes. It shall be noted. Thank you very much.
Thanks, Phil.
Mr. DeLaquil.
And not to keep ganging up on Mr. Pawa, but let me tell you all the other reasons why global warming public nuisance suits are a bad idea. Matt began his remarks by saying the question is, who should pay? And I would say that the question really is something different. It's who should decide who pays? Should we decide how to address the pressing challenges of global climate change through tort suits? And there are a lot of global warming public nuisance tort suits out there. It was mentioned that I'm a Johnny Cash fan, and there's a famous Johnny Cash song, I've Been Everywhere, and the plaintiffs in global warming public nuisance suits are really like I've Been Everywhere. Annapolis, Oakland, New York, Vermont, Boulder, Minnesota, Hoboken, Delaware, Charleston, Honolulu, King County, Anne Arundel County, Rhode Island, Baltimore, San Mateo, Santa Cruz. I'll stop there, but you get the idea. This is about a decision to try to use tort law to hone in on a policy choice and to force that choice through what is effectively ruinous litigation in dozens of venues around the country, in state court, so they can't be MDL'd, which we heard so much about, including some comments about how maybe the defendants would like that. Well, you can't do that here. And the defendants are exactly who you would think. The New York suit, it's BP, Chevron, Exxon, Shell, essentially the companies that are typically called super majors, except for the state-owned oil companies you won't have jurisdiction over under the Foreign Sovereign Immunities Act. But I think we may be nearing the end of the road. Earlier this year, in a decision of the Second Circuit called Chevron versus City of New York, the court really, in my view, hit the nail on the head. And this was, in my mind, something of a second best suit. Phil mentioned that when the global warming public nuisance industry began, the hot theory was really federal common law against the parties who actually emit greenhouse gases. In that case, it was primarily electric utilities. With that door being closed, they've now moved to state common law, something that I don't think people believed 15 years ago you really ought to be using, and against the producers of fossil fuels who, while there are some emissions associated with that, are not equivalent to the end of pipe emissions out of a power plant, for example. And in Chevron, the Second Circuit took what I would call an intellectually rigorous approach to this issue, and they said, this purports to be a state law tort suit, but in our system, can you have a state tort suit? And the court looked at this issue of can you have a state law tort suit for global warming in a way that looks really a lot like any federal common law analysis. Should this be an area of federal law, a federal enclave? And that's really what interstate conflicts have been, dating back certainly to the Georgia versus Tennessee copper case around the turn of the century. And the court looked at it and said, well, of course, it needs to be federal law that governs this type of substantial interstate problem. And once the court made that decision, it was a pretty easy case. As Phil mentioned, the Supreme Court in Connecticut versus AEP had decided 9-0 that Congress had spoken to the question of how it wants interstate pollution issues to be addressed. It did that in the Clean Air Act, and as such, there was no room for a federal common law remedy. I think we may hear different views on the Chevron versus New York case from Professor Adler, but to my mind, it's exactly right. It frames the issue in what is a pretty realistic way that these lawsuits are an attempt to change behavior. They're not a traditional sewer suit. They're not someone who's been delayed in the delivery of their goods or whose car has hit a ditch, swerving to avoid a tree in the road. They're an attempt to push regulation to the preferences of the activist and the plaintiff's bar. And in my last few minutes that are remaining here, I do want to note that I disagree strongly that global warming public nuisance is really anything like the traditional application of nuisance law. Take the question of what is and is not a substantial and unreasonable harm. One of the critical inquiries in tort suit, to my mind, far from being like the log in the road, suing the energy producers that have made modern life possible, that have made the Industrial Revolution possible, is like suing the road for being a public nuisance. Roads generate tremendous externalities. There's pollution off the sides of the roads. There's deaths. There's children who are struck in the road. There's motorists who are killed in accidents. They facilitate drunk driving, which could never happen if there were no roads to drive drunk on. There's externalities associated with everything in life, but energy that's the road. That's not the log in the road. How do you attribute harms between producers and consumers? It's not so simple to say where you should place the onus of any regulation. If you have a chicken farm that's polluting into a river and fouling the water, or 3 or 4 or 6 or 7 or 12, maybe it's simple. But where you have hundreds of years of carbon deposition in the climate, it's not a simple question. And I'll take one last example, which I've stolen from a colleague. Take the case of a Royal Dutch Shell oil field in the North Sea. So let's say it's in the Norwegian economic zone. Is this a Norwegian issue because that's where the oil's produced? Well, then it goes to Sweden and is refined. Is this a Swedish issue because that's where the oil is refined? Is it a Netherlands issue because that's where Royal Dutch Shell is headquartered? Maybe their law should control. But Shell's actually incorporated in the United Kingdom. Should they law control? Then the oil gets shipped to the United States. Let's say they bring it in Louisiana. Is that where the law should control? Then the oil's used in all 50 states by different consumers for different purposes. Whose conduct do we want to abate there? Global climate change is a problem, but it's not a problem you solve with tort law. Thank you.
Thank you very much. And now we have, I feel like this name you should be on the Nashville stage, frankly. Professor J.B. Ruhl. Right? Doesn't it sound like it?
Thank you, Ann. Well, welcome to Music City, also known as Nash Vegas. Glad you're all here, and I'm glad to be here as well. Thank you to the Law and Economics Center for inviting me. I am this semester teaching a seminar on climate change governance. And a few weeks ago, the topic was climate change litigation. In anticipation of this panel, I decided I would mine my brilliant student minds for ideas and perspectives. And I have one student who's writing a paper on obstacles to the merits, addressing these cases. What are the various obstacles, right? But then we said, well, okay, what if we get to the merits? What if some court in Anchorage or wherever, in whatever state, says, forget it, I'm getting to the merits. All right, how do we think about that? And we posed 2 flip side questions. One is, if these claims are not actionable as public nuisance, what is? What I mean by that is, how do we draw doctrinal boundaries in such a way that these cases aren't in, but other kinds of cases are in public nuisance? What are the doctrinal boundaries? I don't care about the political for now, or any of the other issues. What's the doctrinal boundary? But the flip question is, if these claims are actionable as public nuisances, what's not? Right? How do we contain this if we draw the doctrinal boundaries so that these are in, what isn't in? Now, to illustrate, we can compare these cases to a classic public nuisance case that Mark mentioned, Georgia versus Tennessee Copper, 1907 decision by the US Supreme Court. It involved copper smelters on the Tennessee-Georgia line. They were just a mile to 2 miles away. Sulfur emissions from the copper smelters precipitated out as acid rain in Georgia and Tennessee too, probably, and damaged crops and orchards and forests. There had been previous private nuisance claims, Madison versus Ducktown Sulphur, in the Tennessee courts. The Tennessee courts found that the smelters were liable for private nuisance. The lower courts ordered injunction. The Tennessee Supreme Court said, no, we're not going to enjoin these plants. They're too economically valuable. We'll award damages. Georgia then steps in seeking injunctive relief later. And I've got 2007, 1907, the Supreme Court ruled that it would not require a sovereign to accept damages as the remedy. And literally 10 years of jockeying back and forth, the Supreme Court had to come back in 2016 to sort of monitor what was going on, but essentially imposed a judicially created quasi-regulatory regime requiring monitoring and placing limits on the smelters. Okay, so that is a classic public nuisance claim, multiple interstate emissions. Now let's put that up against these climate change cases and look at the attributes. I'm not going to talk about doctrine yet, just look at the attributes. First of all, who are the defendants? In Tennessee Copper, it was a small, closed set of identifiable pollution sources. Who are the defendants here? Well, the named defendants are a small group of the major carbon majors. But as we'll get to in a minute, and I think is already fairly obvious, you could describe the entire world as the defendants, given the actual causal chain involved in what's going on. Auto manufacturers, road builders, I mean, we're all responsible for it. We know that. How about causation? In Tennessee Copper, very clear cut. Very clear cut. In these cases, clear cut up to a point and then very complex. So I'll break it down. The chain links in Tennessee Copper were very few. They're producing copper, sulfur emissions rise and mix and precipitate out locally, generally, locally within a regional area and cause injury to crops. That's it. End of story. In the climate change case, burning, you have to produce fossil fuel, burn it, greenhouse gas emissions rise, they distribute globally, and from there, very complex causal story about what actually happens on the ground as a result of climate change. How about the temporal dimension? In Tennessee Copper, very short-term story. Here, as we've noted, greenhouse gases had to build up for centuries. Climate change will transpire over centuries. So it's a very long, attenuated, temporal causal chain. The attribution in Tennessee Copper was super easy. There was no one else to point to. No one, the smelters didn't say it was anyone else. It's like, yes, it's us. Okay, we're the cause. What to do about it is different. Here, of course, the attribution science is very complex. All greenhouse gas molecules are equal in terms of the harm they do to the climate. GHG source link to specific harm is a very tenuous process to try and understand. Intervening actors in Tennessee Copper, absolutely none. Smelters, farmers being injured. Of course, in climate change context, there are multitudes of intervening actors. Someone produces it, someone has to refine it, someone has to burn it, someone is driving cars, someone has to make the cars so people can drive the cars on roads, right? And in fact, it's the plaintiffs, the public plaintiffs in many of these cases, that are within the causal change by promoting development, by building roads. They even make tax revenue off the sale of gasoline. Other contributing causes, none in Tennessee Copper. In the climate change cases, climate change is exacerbating some pre-existing risks, flood, fire, et cetera. So we got to sort of tease that out to figure out who caused what. Is there comparative fault? I mean, there was none in Tennessee Copper, whereas here, we're all to blame, and how do you distribute that blame? In terms of harm in Tennessee Copper, pretty straightforward measurement process. What's the value of a corn crop or an orchard tree? Here, I don't know how we measure the damages, the incremental costs of adapting, or the component of the harm that was caused by climate change and not just your typical flood. Complex. Mitigating damages. There was nothing the farmers really could do to mitigate damages. They had no way of keeping the sulfur dioxide rain, off the crops. Whereas here, we could all cut back on our carbon usage, our fossil fuel usage. The benefits, of course, in Tennessee copper were copper. The benefits here, the sort of global economy and society. The remedy there, of course, damages were awarded in the Tennessee courts. The Supreme Court was towards an injunction. There was a period of time when the copper companies, after the Supreme Court ruling, were paying into a fund while they were trying to figure out how to reduce the emissions. The 1916 Supreme Court opinion said, not good enough. We're going to actually now keep an eye on you. You've got to reduce emissions. So these are very, very different. I think we all know that. This is obvious. Some of these reasons, some of these attributes of the climate change cases are why I think courts are presenting obstacles to the merits. But if we get to the merits, we have to ask, well, are these in or are these out? And so let's go back to my first two questions. If these are out, if these are not public nuisance claims, actionable, what's in? Plenty. I mean, between Tennessee copper and these cases is a lot to work with. Now, how we actually draw the doctrinal boundaries, exactly where, is a little fuzzy. I'm not sure. I don't have that worked out. But there's plenty that's still in the public nuisance bucket that would be actionable, even if these are not. If these claims are actionable as public nuisance, what's not? I mean, I think this would open the door. I don't know exactly what the doctrinal explanation is, if it's as simple as say, Matt suggests, but it applies to these kinds of harms. Ocean plastics pollution. Let's sue DuPont or Exxon because you have to have petroleum to make plastic. The internet, of course, people are talking about that. We'll sue Facebook. Microfibers, let's sue Patagonia. But we're all, putting on the fleeces and washing them, or maybe we're not all anymore now that we know that microfibers aren't good. Where does it end? I don't know. Capitalism. Let's sue Goldman Sachs for the evils of capitalism, being facetious there. But there has to be an end. And how do you draw the end boundaries doctrinally? How do you draw them if they're in? If they're out, how do you draw them if they're in? Thank you.
Thank you very much. And last but certainly not least, Professor Adler.
Well, great. It's a pleasure to be here. It's always fun to be at these conferences, and it's fun to be up here on stage with some old friends. As JB just noted, there are a lot of complicated questions about these cases, about the substance of them, a lot of ways in which the climate cases are different from other sorts of cases that we think about in terms of public nuisance, lots of questions about whether or not plaintiffs can make all the requisite showings they need to for them to go forward, whether it's have they properly articulated the right cause of action, have they identified the right defendants, does the legal theory work under the law of the jurisdiction that is being filed, do they have can they demonstrate the attribution that they need to demonstrate to connect the activities they're challenging to the harms? Is the type of relief they want available? Does the court have jurisdiction? Are there defenses of unclean hands? And so on. Lots of questions there. And I think they're important. I think courts are struggling with them. What's interesting, and the courts, I should say, courts are struggling with them even though, at root, many of the sorts of harms that are being alleged are the sorts of harms that, as Matt noted at the very beginning of the panel, we have recognized as actionable within our legal tradition for centuries. I use my property in a way that causes water to collect on yours. Can you sue me? Common law, the answer has been yes for hundreds of years. Could even sue the road, unless it's a government, in which case the defense is sovereign immunity. But there are plenty of cases throughout the United States suing roads over things like unreasonable stormwater runoff or the causing of flooding of downstream lands. But these cases are complicated because of the scale. We're talking about an atmospheric phenomenon. We're talking about sources of emissions that are ubiquitous and so on. So they're challenging. And certainly plaintiffs in these cases have their work cut out for them in terms of being able to do all the things that you need to do to make those cases go forward. What's been interesting about the climate change litigation that we've been seeing to date is we're not getting to that point. We're not getting to the point of can the plaintiffs, as was talked about in the prior panel, prove the things they are alleging. Courts are being given various off-ramps, and they've taken them. And the particular off-ramps I want to talk about are those that involve the question of whether or not there's something about federal law, federal environmental law in particular, that prevents these cases from going forward. We have federal environmental statutes. We have a Clean Air Act. According to the Supreme Court, the Clean Air Act applies to greenhouse gas emissions. We can debate whether or not that decision was correct or not. I know on this panel we would disagree on that point, but it is what it is, and statutory stare decisis is very strong. That is not going to be undone. And federal law is supreme. So if there are things about federal law that say these cases can't go forward, then they don't go forward. So does federal law say these cases can't go forward? And the answer is it depends. Earlier in the panel, some of my co-panelists mentioned a case called AEP versus Connecticut, American Electric Power versus Connecticut. This was from the prior generation of nuisance suits against emitters of greenhouse gases. And those suits were filed under federal common law because, as would seem kind of intuitive, if you're talking about pollution that crosses state boundaries, that is interstate in nature, it would make sense to have federal law be the source of the decision, because that could be fair, that could be neutral. Avoids the problem that we're all familiar with of plaintiffs seeking home court advantage in terms of what jurisdictions they file in. And that's particularly a concern in cases that involve parties from more than one state. And prior to the 1980s, federal courts heard claims involving interstate environmental claims, both pollution claims like Georgia versus Tennessee Copper, which JB was talking about, but also a lot of cases involving things like shared resources. And as some of you know, we still have those shared resources cases. There was one between Mississippi and Tennessee argued before the Supreme Court just a couple weeks ago. In 1981, the Supreme Court said in a case called, that we just refer to as Milwaukee 2, that federal common law for interstate pollution is displaced. A lot of people say preempted, but it's wrong. Displaced by the enactment of the Clean Water Act. And then in American Electric Power versus Connecticut, the Supreme Court said, to no one's surprise, unanimously, what the Clean Water Act does for interstate water pollution claims under federal common law, the Clean Air Act does for interstate pollution claims under federal common law, air pollution claims under federal common law. The Clean Air Act does the same thing. It's important to understand the reason the court gave in Milwaukee and reaffirmed in American Electric Power. It was not that it's messy. It's not that it's unfair to one state or the other. It's not that these sorts of things should not be handled in court. The rationale is that federal common law is one potential source of decision for interstate disputes, for matters that concern states more than one, and it is disfavored. See Erie Railroad versus Tompkins. And that the question for federal courts when federal common law claim is presented is, do we have to resort to federal common law because there's nothing else, or has Congress given us an alternative? And if Congress has given us an alternative, we don't care if it's a good alternative, bad alternative. We don't care if it works, if it doesn't work. We don't care if the EPA is doing anything with the power that was delegated to it under the Clean Water Act or Clean Air Act. The fact that Congress has said, we have provided the federal rules of decision means we don't have to use this disfavored thing we don't like, federal common law. Because post-Erie, we believe that federal courts don't do what state courts do in terms of the common law of discovering rules of decision and so on. What's interesting is that's radically different from the law of preemption. The law of preemption has one sovereign's actions, its statutes, preempted, using supremacy, the law of another sovereign. We know as a general matter that preemption is disfavored. How disfavored, we can debate. The case law in that regard is less than 100% clear, but we do know it's actually something of a rigorous test. We are looking for Congress to have affirmatively, not simply placed a flag in the ground, but actually have done something to make the state law go away. And that's true whether it's a state statute, state common law, any other source of state law. It's a radically different test. And in American Electric Power versus Connecticut, the Supreme Court said quite explicitly, we're saying nothing about preemption of state law because it's a completely different test. And while there may be all sorts of policy reasons why we like the idea of a single rule provided by federal law for dealing with interstate pollution disputes, that's a choice for Congress. And preemption is based on what has Congress done, and not what would, as a policy matter, be preferable. Beyond that, Supreme Court in a case called International Paper versus L.L.P, and I'm probably mispronouncing L.L.P, but so be it. Supreme Court said that despite Milwaukee 2, state law-based common law claims for interstate pollution can go forward, provided they are based on the law of the source state. Basically, the idea is we're not going to allow you to be opportunistic. We're not going to allow you as a downstream state to pass a really stringent rule or adopt a really stringent rule for pollution and then export it to the upstream folks. But what you can say to the upstream folks is, if you're protecting your own people with this rule, you've got to be sure you're protecting the downstream folks to the same extent. That, like Milwaukee 2, was a Clean Water Act case. There is no reason why that should not apply in the air pollution context as well. In fact, every appellate court and most district courts that have asked the question have concluded it applies to air pollution as well, with the half exception of the Second Circuit case that was mentioned before. I know I'm out of time, but let me just say I disagree radically with my friend Mark on the substance and thoroughness of that opinion. The shortest way to say it is it's convenient that it was issued on April 1st. It misstates at a fundamental level certain aspects of our federalist system. For example, claiming that state regulation of environmental law is based on what the federal government authorizes or permits. That's backwards. That's a grotesque caricature, or not even a caricature, I mean, it's a grotesque warping of the way our federalist system works, where state law is not permitted by the federal government. It can be preempted by the federal government, but it doesn't exist because the federal government authorized it. And there's no reason within our federalist structure why state decisions to adopt more stringent regulations of air or water pollution, which is clearly allowed under federal pollution control statutes, is any different than state choices to use common law litigation to adopt more stringent standards within those states either. So my own view is that the existing doctrine is that these cases, climate change cases, whatever their problems, whatever their difficulties, however challenging it's going to be for folks like Matt to make their case on all the things we've been talking about, there's nothing in federal law at present that should stop them from going forward. Existing doctrine should not result in them being preempted. That those defending these cases are going to need to find other grounds to either get these cases dismissed or they're going to have to defend them on the merits, unless Congress decides something else. And I'll stop there.
Thank you very much, Professor Adler. So we're halfway done. I'm just trying to see if you're paying attention. Now it's a chance for some interdiscussion, and frankly, Matt, are you going to take that sitting down?
Of course not.
Very good.
Thank you. Connecticut versus AEP was one of the first climate change tort case. We've heard a lot about it. It's been mischaracterized quite a bit. The reason that case was filed and the pattern of how these cases have evolved has been mischaracterized. The reason Connecticut versus AEP, which was a suit against large direct emitters, owners of coal-fired power plants seeking injunctive relief. The reason that was filed under federal common law was because of the nature of the case. It was against direct emitters. It was seeking injunctive relief. This was 2004. The world was quite different then. The injuries from climate change had not started piling up. And look around you, the injuries have now started piling up. So an injunctive relief case was very appropriate at the time for states. 8 states filed that case, trying to mitigate the harm from global warming with the traditional federal common law injunctive doctrine, which you heard about, that went all the way back to Georgia versus Tennessee Copper. And despite the attempts to make Georgia versus Tennessee Copper seem normal and ordinary, and climate change tort law very extraordinary. At the time, 100 years ago, the idea that a state could sue copper smelters, and there was, by the way, a comparative fault issue in that case. The Ducktown Sulfur Company was the smaller of two defendants, so there was a comparative fault issue. Obviously, it's much bigger in climate change. But the idea 100 years ago that you could bring a case like that was considered radical. And actually, that wasn't the first federal common law nuisance case. The first one was a case between Missouri and Illinois, Missouri suing Illinois for allowing sewage and the pathogens in sewage, bacteria, to come downstream in the Mississippi River. And the US Supreme Court said in 1901 that that case could go forward on the merits, notwithstanding the fact that this case was on the absolute frontiers of microbiology. And it was another one of these complex cases that at the time may have seemed quite extraordinary. And we look back at it now and we say, well, of course you can sue over sewage pollution, or of course you can sue over what we would now call acid rain. But this was 1907, Georgia versus Tennessee Copper. And the case went on, as you heard, for 10 years with a special master. So in addition, I want you to know, in Connecticut versus AEP, we pled alternative state law claims. It's not like we've been shopping around, oh, give us a federal common law theory, give us a state common law, we'll take anything. At the time, we were very well aware of this dynamic, that the law could change on us and that state law might come to the fore. How would that happen? And it did happen during the lifetime of that case. Mass versus EPA was decided. So when we filed Connecticut versus American Electric Power, the federal government was actively saying there's no regulatory regime applicable to greenhouse gases. The Clean Air Act does not apply. And that created a vacuum in federal law under Milwaukee 1 and Milwaukee 2, which allowed us, so said the Second Circuit, agreed with us, to apply federal common law. Now, by the time it got to the US Supreme Court, the US Supreme Court had overruled to the EPA and said, no, the Clean Air Act does allow you to regulate greenhouse gases. So the law changed, and the US Supreme Court said, you're just too late, basically. Sorry, if you'd beaten out Mass versus EPA, the law might be different, but now there's regulatory authority. And we had pled state common law claims in the alternative, recognizing that might happen. It's not like we years later we're like, oh, let's try state common law. That was there at the very beginning. So what you've heard is counterfactual to the history of how this law developed. The latest round of climate change cases are different. They seek monetary damages, and they go after the producers of fossil fuels, and they say, contrary to what you've heard, right in them in black and white, that they are not an attempt to solve global warming. They say, right in the legal briefs in those cases, that they are disclaiming any attempt to try to change the defendant's behavior. In fact, I think it says that right in some of the complaints that I have filed. And they mean it. That's an honest, truthful statement. There is no attempt to change behavior in those cases. It's a question of allocation, which is where I started with the presentation. Who should pay? And the response that you've heard is, well, why should the oil companies have to pay? Because isn't that just a sub salientia way of spreading the costs among the consumers, and isn't that appropriate for the legislative branch and the executive branch? But you can say that about any tort case against a manufacturer, whether it's product liability or public nuisance or anything. I mean, why should the manufacturers of PFAS, case I'm involved in, made by DuPont 3M, why should they internalize the cost of their product? Why should, I mean, for that matter, in a negligence case, why should a shop owner internalize the cost of having to keep their floors dry so that they don't get sued for slip and falls? So the argument that an externality, trying to force a company to internalize the cost of the harm and stop externalizing them onto the public or onto the private plaintiff landowners, and some of these states and cities are suing as landowners, so there's private nuisance as well as public. It proves too much. It proves, because it could apply to every single tort case. Well, you're trying to have a law of, you're trying to create judges, put judges in the business of solving the problem of slip and falls, and that the legislative branch should do that. And you can't force shop owners to internalize the cost of slip and falls. Well, of course you can. That's called tort law. I mean, this is an argument, what you're hearing is an argument to get rid of all tort law. It proves too much. It just proves too much. Yes, there are many states, and there's many state laws that would apply if we're applying state law in this latest wave of climate change litigation. But that's because the defendants have caused so much harm in so many places. So is the rule of law going to be, if you harm a lot of people, you're exempt? But if you harm just a few people in Georgia, well, then you can be held liable. That's what you're hearing. That can't be the law either.
Okay, I'm stopping you there.
I think I'm done.
Your blood pressure is rising, and I'm very concerned about your health. All right, anyone else want to respond? All right, Phil, but let's keep it on time here, Phil.
Yeah, I got it. All right. I'm going to answer the question that Matt just asked. It's about negligence. All these other tort theories are about wrongful causation of harm, not just who should pay. Wrongful causation of harm. The whole concept of unreasonable harm that Matt put up on the board that we've heard about, that is a private nuisance concept. You injure someone on the neighboring property who ought not bear that harm. That is a unreasonable harm to that person, even if you're engaged in lawful conduct. That's a private nuisance concept. Public nuisance requires, and if you go back to the history, really quasi-criminal conduct that was unlawful conduct. There is no benefit to a public nuisance. It is by definition not beneficial to any, that doesn't have benefits. And so that's how this tort has been tried to be twisted over the past 20, 30 years, where you take what's supposed to be a public right and then you make it anything in the public interest. You take unreasonable conduct and you just make it unreasonable harm. Someone ought not bear the harm they bear. I don't know, I've never heard of a reasonable harm, that someone had an injury that they ought bear. So that makes that irrelevant. If you take causation, you make it anything that contributes to the risk. You get rid of that element. You take the control and you say, well, you control the product, you control the marketing, even if you didn't control the causation of the nuisance. And so that is how this tort is becoming indefensible, because they keep knocking down and changing the fundamental elements that have existed in this tort for 700 years. I'm done.
Thank you very much. That was very succinct. All right, so let's take a couple of questions. So the first one is, how can we say in a legally sensible way that any particular fire would not have happened but for climate change? It's probably aimed at you, Matt.
Yeah, well, the substantial contributor rule would allow you to put on scientific evidence to demonstrate that the odds were stacked in favor of a particular event happening by climate change. And the scientists are getting better and better and better at this. It's called DNA detection and attribution science. And they're able to look at particular climatic and weather events and demonstrate quantitatively how much more likely they were because of anthropogenic climate change. And that is what the law recognizes as causation.
All right, is the end goal of climate litigation to force manufacturers to build the environmental costs into what they charge in order to reduce public use and change public behavior? Who would like to take that one?
Yes.
I so appreciate your brevity.
No.
All right, great. We got a yes and we got a no. All right, so this question involves Minnesota, so I have to say it. A thought experiment. Minnesota corn yields have gone up by 2.8% due to climate change. Can Minnesota sue entities who reverse climate change?
No.
Minnesota has sued the energy industry. They've actually brought the reverse suit. It's a fair point that in some areas, in some aspects, there could be positive effects. I don't think you're going to find any scientist who would suggest that they balance the negative effects in total. But that's a fair point. There are winners and there are losers. And if there are winners, so many winners, and so many losers with this particular problem, it does call out for a democratic solution in a way that shop owners slip and fall cases don't.
If I could jump in there.
Yes.
I agree with Mark on that point, in the sense that it calls out for a legislative solution. I've written a bunch of papers, or they're long enough you might think of them as sleep aids, but arguing for various things that we should do or shouldn't do, and that the legislature should do them. But the interesting is here, in a lot of contexts, the question is not, in a perfect world, would we have legislatures that are being more proactive about these problems? The question is if legislatures fail to be more proactive, should courts rush to embrace doctrines like, say, preemption, preemptively and in doctrinally improper ways because they just don't like the difficulty or the volume or the scale of the cases? Right, so the question before the panel were should the legislature figure out a way to balance the burdens and benefits of climate policy in a way that deals with this at the level and the scale of the problem? I think Mark and I would agree with that principle. But if the question is, should or even can courts properly dismiss these cases on the claims of federal preemption when there's nothing in federal law that preempts them, then I would profoundly disagree, because it's not the place of the court to say there are better ways of dealing with this problem than litigation, particularly if, and it's an if, there are plaintiffs that can show that they suffered the sorts of harms that we have traditionally recognized as being actionable, right? So we know flooding traditionally is actionable. Can New York show that that its flood-related costs and the expenses it has to bear adapting to and trying to prevent those costs are greater by a certain magnitude due to climate change, and then apportion that among the defendants? Maybe, maybe not. There's a 300-some page law review article in the Columbia Journal of Environmental Law from a year or two ago documenting how much attribution science has improved over the last decade or two. And it's remarkable. And so the answer is New York might be able to show that. But traditionally, that's the sort of harm that would be actionable. And just because it's part of a bigger problem that it would be nice the legislature did something about, traditionally has not been an excuse for courts to say, oh, not it. And my concern is that that's what courts are doing when, that's not a proper way of judges exercising their responsibilities.
All right, thank you. This question is specifically for speakers Goldberg and DeLaquil. Do you object to state court public nuisance injunctive relief? And is your objection, if you have one, based on damages being sought?
So it's funny, I had up on my screen here a quote from AEP saying, quote, "that borrowing the law of a particular state would be inappropriate." So, I mean, if they didn't say this wasn't a state law case, because as Matt said, that part of the case was not before the Supreme Court, just the federal law claim was. But if you go back and you look at what, I'm gonna try to make this in my mind simple, hopefully for everybody else too. Public nuisance and how it's being used in these cases are such a distortion of what the doctrine was about for all along. The idea of a public nuisance is that the government can sue somebody to stop blocking the road, blocking the public right of way, and clean it up. So injunctive relief or abatement. And so that's what the remedies are supposed to be for a government. It's not supposed to be damages. That's only if a private person has a special injury from that public nuisance, then they could bring a claim for that public nuisance. So, but what these claims are really government seeking damages for a public nuisance, which and we're getting 5 years from now, we'll be back here arguing that point. Like, are these damages cases, are these abatement cases, are these injunctive relief cases? And so, ultimately, this is not what the tort was all about, because they're not abating the nuisance. The nuisance, if there is a nuisance here, it's the atmospheric presence of carbon dioxide that is having its impacts then down in an individual and creating damage. These are damage cases. So if the states then said, okay, well, we're allowed to use injunctive relief, and what are we going to enjoin? So when you say, can the states use injunctive relief? That would be a traditional power of theirs, but to do what? What are they enjoining? And do they have the authority to enjoin that? And so I don't know that I can answer that sort of in the abstract, but maybe Mark can.
I'll answer it in the abstract. I don't see a big difference between a suit seeking an abatement fund, which is essentially damages, and a regulatory solution through an injunction. I think the type of damages at the scale that they're being sought in a coordinated litigation campaign across the country is tantamount to an attempt to regulation. I don't think that the end goal of these suits is to have 25 or 30 or 40 abatement fund trials. I think it's a solution that ends up with an abatement fund and a change of behavior. That's what I think the goal is, and so my objections would apply there as well.
And the wrongful causation objection that I've had before would apply as well.
All right, well, it's 4:42. I know you're tired. I know you're weary. I know your plans do not include me. Yet still, here we are at the end. So let us thank our panel for a great discussion.